Hello, Anne. How are you?
Thank you for being with us this morning. I know this is a topic that everyone is interested in. What are the legal implications of what's going on for their business? So I'll let you to speak. You'll have about 10 minutes.
That's fine. Thanks, Anne.
Thank
Good
you.
morning, everybody. Pat Sheehan, solicitor here in Killarney. Just COVID-19 and all the issues that surround it have thrown the whole world into turmoil for the last 3 months. I'm not going to discuss this morning. My colleagues will discuss all other issues kind of in relation to employment law and different things like that. However, there are a number of legal issues that have relevancy and people should be aware of. So I suppose without further ado, maybe I'll go on to them. And just the first thing, consumer law. Consumer law is that when people go into a shop, when they go into a business, when they order a meal, when they book online, most of the time they are consumers. So the Consumer Regulatory Authority in Ireland on the 23rd of March 2020 advised that consumer law still applied. COVID-19 hasn't taken away any rights or obligations. So again, from the point of view of running a business or being engaged in a business and dealing with the general public, consumer law applies. So in the context of COVID-19, Irish businesses, particularly those, say, selling PPE equipment or sanitizers or home officing and things like that, Irish businesses cannot price gouge, and that's very specifically outlawed. They cannot price gouge on protective equipment and on sanitizers. Businesses can't engage in aggressive commercial practices, and businesses can't try and impose unfair contract terms. So that's very, very important. It means, just again, if you're in a dominant position or you have something that somebody needs under consumer law, you're not entitled to flex your muscles and try and screw over your opposite number. So that's very, very important. So again, consumer law does apply and consumer legislation does have teeth if you fall foul of it. For people working remotely from home or for people who require remote working facilities, the telecoms and utilities industry have given a commitment to ensure extra assistance to consumers working remotely. So again, you might say, what does this mean? If you found that a broadband provider or somebody like that wasn't doing what they should do, you can try and agitate under consumer law to get them moving quicker. And it's very important. They have given a commitment and they should be held accountable and to task on that. For businesses who are looking for payment, again, my business, an awful lot of payment is made over the years by way of check. If I suddenly move and say I require online payments now, or I want remote credit card payments or PayPal or whatever it is, if you're getting into that new payment methods or requiring new payment methods, you must tell people, consumers, at the earliest possible opportunity. So if I'm dealing with Joe Bloggs, he's used to paying it by way of check, but I no longer want to check. I need to tell him at the earliest possible opportunity that he has now to pay online or PayPal or whatever it is. You also have issues with regard to online shopping. So again, people are migrating more and more to online. If you buy a goods in a shop, and you're a consumer, you can return them only if they're faulty. If you buy goods online, you have 14 days within which to return them for whatever reason. So again, you're dealing in online shopping, you have different consumer rights to when you're going in and out to a physical shop. And again, it is worthwhile for you, if you are buying stuff as a consumer, to know those rights, but likewise, if you're selling, to know that people have the rights to change their mind. And if they ask to change their minds, then you are actually obliged to facilitate that. Again, from the point of view of consumers or even for yourselves in business, you should beware of paying too much up front. And again, this is where somebody front loads a contract. This is something that perhaps you would have seen maybe 10 years ago in the recession, where people would have looked for maybe half or three-quarter payments up front. Their idea was that they would go into liquidation and then you became an unsecured creditor and your money was gone. For any of you operating in business or buying stuff from any business, these are uncharted waters. There are a lot of businesses that are finding it going tough, and there will be people who will go into unscrupulous activities. So again, always beware. If you're buying X, if you're asked for 90% of it up front, you have to be very, very careful that you're not being hoodwinked or you're not being brought into stuff. And then maybe just by way of interest to people is that as of the 2nd of June, the consumer regulator has introduced guidance for consumers buying COVID-19 face masks. And in actual fact, if you're engaged in buying face masks or just want to get them for yourselves, there's actually quite significant details as to what type masks should be, how they should work, how all of this should be done. So again, it's trying to sort out your Dell boys who are trying to sell you shoddy stuff, that there are specific specifications on all of this equipment that people should be adhering to. So again, consumer law applies, consumer law should be adhered to. If you're selling, you have to be aware that consumers' rights still apply. If you're buying, just be wary and just know about consumer law, that it does apply. Just I suppose moving on, data protection. For most businesses or most people, they would be aware that over the last number of years, there has been data protection, the protection of data. You hear all this thing about Facebook, in the American elections, about Cambridge Analytica and all the rest of it. Data is big business. You as a business control data. So if you have an employee or 20 employees, if you have X, if you have Y, you will control data. You will be a data controller, and therefore data protection legislation applies to you. By way of stuff that people should know, but it's actually very simple. An awful lot of data protection breaches occur through the use of emails. And again, business has migrated online. I do an awful lot of business online. My customers are doing a lot of business. So there's an incredible amount of email data or email stuff going over and back with documents scanned and so on and so forth. There are just a couple of things. Data breaches occur where you don't have a correct recipient. I am sending an email to X and it goes to Y. That is a data breach. I send an attachment. So I am sending to X the correct email, but I then attach an attachment that belongs to Mary X about something entirely different. In my business, if I was to send somebody's family law proceedings or such like to a thing, there could be reasonably significant breaches. Again, for any business, there is data that is not so significant, but there is very personal data, financial and otherwise, that you must protect. In any emails, you can CC an email which is open, or you can do a blind carbon copy which is closed. Again, sometimes in circulating, you may disclose email addresses. That can be in itself an email breach. So therefore, for yourself or your staff, again, what can seem to be innocuous may not be so innocuous for your customers if you start sending emails around or email threads that have literally everything on top of it. So again, it is very important that people would recognize that the use of emails is fundamental to business, but that again, from the point of view of data and data protection, that this should be monitored and that you should have procedures to deal with it. If a breach occurs, you have to deal with it then. You may not have, economic loss, but you may have loss of reputation. So in the middle of COVID-19, you certainly do not want loss of reputation to add to everything else. Employers, where you have employees working from home, again, you may say, I want to monitor Johnny working from home. I want to keep an eye on him that he is working 8 hours a day. You can do this, but again, it has to comply with GDPR requirements. So it's not appropriate that you would kind of have some little spy software or something like that you can check on people. That is not appropriate. You then get into employees returning to work next week and the weeks afterwards, where you have medical data. Medical data is a special category of personal data. It is enhanced data. So my name, my address is one type, but my actual medical data is special personal medical data, and that has to be minded and monitored carefully. Public health requirements in the current crisis override a lot of GDPR, but again, you have to be very, very careful, and you have to be extremely careful if you have issues regarding COVID-19 on your work premises, and that has to be dealt with in an appropriate manner. COVID-19 does not stand in the way of healthcare. The directions of the emergency legislation in that would supersede in a lot of cases, and public health must take priority. But again, data protection has to be looked at and monitored. If you have to process employee data, and employee data or medical data is to be used, you must do it in a lawful manner. Anything you're doing must be transparent, meaning your staff or your customers or whatever must be aware of it. It must be confidential. You can't just hand it out willy-nilly. Any data you hold must be minimal. So again, if you're asking staff for data, it must be pertinent to what you need it for. So you don't need their entire life history to be stored on a laptop. You need minimal data. And then there must be an accountable person or accountable organization. So if I hold data on behalf of my staff, then I'm the accountable party for it. Again, it sounds sometimes worse than it is. A lot of the times you just must be sensible and prudent. So again, the fact that COVID-19 is around us doesn't mean you lose your head and start firing off emails and doing all sorts of foolishness. You comply with the law as it is. But GDPR applies, and parties can make complaints to the Data Commission. The Data Commission has teeth to follow up on this if needs be. Directors in companies, if you're a company director, you normally act in the best interest of your company. When times are tough financially, as they may be going forward, you have to act in the best interest of both your company, but also you have to keep an eye on creditors. All decisions you make must keep an eye on creditors. A creditor of a company doesn't have a direct right of action against you as a director. However, a liquidator does if issues go wrong. And even this week in the High Court, a case of Winning Ways Limited, 2 directors were restricted for a period of 5 years. Not that they did anything completely out of the way, but they kept the company alive for longer than it should have been. And they paid themselves, and they got pensions paid, and they got some certain things paid for them to the detriment of creditors. In these difficult times, you should be taking proper advice if you're a director, and you should keep proper records. That's absolutely paramount. Contract law, again, in COVID-19, contract law doesn't go out the window. Any agreement you make with suppliers otherwise are contracts. COVID law might allow for one particular thing, which is frustration. Contracts can be frustrated when an intervening event occurs. Neither party is party to that, but an intervening event occurs that doesn't allow the contract to be fulfilled. That can be where things are illegal, where it's impossible to perform, or that the purpose of the contract fails. COVID-19 may or may not be such an event. One thing to note is that because a contract takes longer to perform, or a contract is more expensive to perform because of COVID-19, that doesn't mean it's frustrated. So we may buy a house that costs a bit more than we think it is worth at this point in time. We still are obliged to go through with it. So that's something very important to note. In general terms, courts are open but limited. Government agencies are working. The planning authorities are still working. Business is operating as normal, but in a different way. So again, while COVID-19 is there and everything and everybody must react to it, law, like everything else, still operates, but it's dealing in a different way. I'm Pat Sheehan, solicitor. I'm very thankful to you for listening, and I wish you all the best and to keep safe. Thank you.